Hello and welcome to all of you that have joined us today for a webinar on a very important subject and a matter that's top of mind for many people these days, and that is the 221G issue. My name is Ron Hoppe, and I am the CEO of WorldWide HealthStaff Solutions, and I'm very pleased to welcome all of you to this webinar today. We're very encouraged to see that we've had individuals register for this event today from more than 20 countries. And I'm also extremely pleased that we have attorney Mike Hammond joining us for this presentation this morning. Mike is one of the leading healthcare immigration attorneys in the United States. He has worked in this area for 31 years. We were just speaking a little bit before the presentation started this morning that Mike said he has staff working for him now that were born after the time that he actually started his firm. So we welcome Mike, and we look forward to hearing from Mike on this very important issue. Just a couple of items to note as we prepare for the presentation this morning. I know that there will be many questions, and I would ask that you just hold your questions until we get to the question and answer period of our time together today. We hope to have a significant amount of time available for that. In our time together today, we will be able to respond to questions that generally apply to the 221G issue. If you have a very specific scenario that relates to your case, we may not be able to specifically respond to those types of questions, but we will certainly take those on board. If you are currently a health staff applicant, we also encourage you and welcome you to follow up by forwarding your question directly to your case manager, and we'll work on that together with Mike subsequent to the presentation today. For those of you that have joined us live, you will also receive a recording of our presentation today within the next 24 hours. And for those that may have registered and aren't able to join us live today, they will receive that a recording of this presentation as well. So with that brief introduction, it's my great pleasure to introduce to you attorney Mike Hammond. And Mike is going to kick us off this morning by just giving us a general overview of what is a 221G. So Mike, welcome. Thank you for joining us. And this 221G issue has been out there now for a while. So if you would just start us off and just kind of set a base for our conversation, just give us an overview of what a 221G actually is.
Okay, thanks, Ron. Appreciate it. And welcome to everyone. Appreciate the opportunity to come and kind of give some information about this topic. So first of all, 221G is simply kind of a generic term. It refers to a particular section of the Immigration Nationality Act, specifically known as 221G. It's just the code number. That's all it is. That's where it comes from. It's technically a refusal of the visa. And that is important to note in future visa applications. If you're ever asked in the future, have you ever been refused a visa? You do have to check, yes, I was refused. I had a 221G. And then you can explain you overcame it or whatever. There's several different types of 221Gs, okay? So again, it's a generic term, but three main types that we see. Number one is what I would refer to as the simple one. I need something. It could be as simple as a birth certificate, a marriage record, a divorce record, the medical report was not complete and you need to go back to the doctor and get it completed. Just, I need something, okay? We refer to those as the simple ones. There's, if you've ever seen a 221G, it's just a standard form document. Most of the consulates use the same ones around the world. And there's a list of check marks where I need this, they've checked it off. And then the easy way to deal with those is just simply give them what they asked for. Okay, that's the most common one that we see. A second one where they don't give you much information on, but is what we refer to as they're waiting on a security clearance issue. There are multiple levels of security clearances that individuals go through before a visa is issued. The Department of State, the consulates do not disclose where you are in that process. But sometimes when you get a 221G and there's not anything checked off and you're not sure why, and there wasn't anything in the questions that indicated why they're asking or why they're delaying your visa issuance, it's because of a security clearance. And then the third one is what everybody refers to administrative processing, okay? And that can mean one of two things. It can mean I need to check on an issue. I think there's something in your case that troubles me as the visa officer, and I need to check on that. Checking on that can mean internally with the supervisor. Checking on it can mean getting back to the Department of State. It can be a variety of things. And then the second part of administrative processing can be they're actually going to verify information. So your petition, for example, says, I am going to work at XYZ facility in San Jose, California. They can actually reach out to the facility in San Jose and say, hey, we have a visa petition sitting here for Maria. She's a registered nurse, says she's going to come work at your facility. Do you know who Maria is? And is Maria really planning on, did you guys really sponsor Maria, and Maria really going to come here and work at your facility? That obviously takes a while for them to do. They contract that out here in the U.S. through an organization called KCC. But that is the situation where they're verifying something. So a couple things that could happen as to how these kind of 221Gs are resolved. I mentioned the first one, the easy one, which is bring them what they want. The second one, though, is the issue where they're troubled by a particular issue. We're going to talk here in a little bit about some of the common reasons. But those issues can be resolved through them getting what's called an advisory opinion from the Department of State. They can be resolved through liaison. They can be resolved through direct communication with the consulate of, hey, what's your real concern? Let us help you address it. Let us explain to you what you're confused about or what maybe we confused you. It can also be solved through litigation. There are a lot of issues that ultimately get litigated, particularly over the last several years, that then that information gets passed on to the consulate if a federal court has ruled on this particular issue. A lot of times, consulates can, as part of a 221G, actually send your case back to the USCIS. So sometimes you'll have noted on your 221G, there'll be a little box check that says we've returned your petition to USCIS for further processing. What that means is they write up a report that says we do not think this person should have been approved because of X, whatever X happens to be. That goes back to the service center that processed your case. They then review it, and they can do one of two things. They can either send the petition back to the consulate and say, we disagree with you. You've raised an issue that we do not believe is an issue. We believe we've properly adjudicated and approved this case. Please proceed with visa processing. And then the consulate will simply call you back in with no explanation and simply say, hey, now you're approved. Okay. The other thing the USCIS can do is they can agree with the consulate, and they can send to your company, to your petitioner, what's called a notice of intent to revoke. So you've already been approved once. Now they're sending you a notice of intent to revoke. It explains why the consulate thinks your case should not have been approved and why the USCIS agrees with the consulate. And then your petitioner will have 30 days to actually submit a response saying, we think you're wrong. Here's the legal grounds, or maybe here's the factual information that disputes this. So there's several different ways things can be resolved. Several different procedural things can happen. And sadly, for most people in a 221G scenario, you're left a little bit in the dark. Because unless it's one of those 221Gs where you're just checking off a box and they say you're missing A, B, C, D, those are clear. All the others, you're not completely told for sure exactly what's happened or exactly why they're raising the 221G issue. We all guess based upon information you tell us that was asked at the interview, but it's still just a little bit of a guess. And the consulates are a little wary of providing specific reasons unless it comes out in a notice of intent to revoke.
Mike, that's great information and a great introduction. I think most of the persons that we have joining us on the webinar this morning are probably registered nurses that maybe are in 221G status currently, or they've got embassy interviews coming up in the next little while, and may be concerned about possibly receiving a 221G. Mike, what would you say, based on your experience and the work that you're doing, what would you say are the most common 221G issues that are facing RNs right now?
Yeah, the most common issues we're seeing with RNs right now is there's about 6 or 7 of them. The one is liquidated damages clauses. Some companies have liquidated damages clauses in their employment contracts. And so the consulates have taken a kind of a strong line on liquidated damages. They do not have the legal authority to completely eliminate them because there's actually statutory law, regulatory law that allows liquidated damages. However, they certainly can take a strong position on them, and they have certainly done so. One of the things that comes out of that liquidated damages issue is the fact that some companies operate not with employment contracts, but with offers of employment. And that's fairly common with a lot of employers in the U.S. Most employers in the U.S. are what we refer to as at-will employers. And so instead of having a contract, they'll have an offer that outlines all the terms of the employment. And oftentimes, the consulate, when they see an offer of employment, says, we want to see an employment contract. They're not really saying we want to see an employment contract because it's a requirement under the law, because it is not. They want to see an employment contract to make sure there's not a liquidated damages clause in the employment contract that is maybe being hidden by the employer who only is providing an offer. So that's a fairly common kind of thing. A second one that we're seeing right now, just started, is about 6 weeks ago, the Department of Labor issued a new regulation that changed the way prevailing wage, at least one source of prevailing wage, is being used. So the OES system, which was a common system used by the Department of Labor to set prevailing wages, was changed about 6 weeks ago. That change is under litigation right now. It's not expected to survive, but for right now it exists. The law says that you have to be paid the prevailing wage at the time of your filing, the time of your I-140. However, which is obviously not today when you go to your interview. So if you go to your interview today and the prevailing wage is $12 an hour, and when your case was filed, it was $11.50 an hour, there's no legal requirement that you now need to be paid $12. Okay. Employers may often raise wages to meet new things, particularly when cases have gone on for a really long time, but there's no legal requirement. So, but right now the consulates are often looking at the new wage scale from the Department of Labor, from OES, and saying the pay should be X. So that is a common 221G that we're seeing right now. It's what we refer to as a training issue. Consulate hears something, thinks that's the new law, doesn't really recognize that that's not the law, and it usually requires some intervention from the Department of State. They have what they call a legal net advisory opinions that will let the consulate know what the law really says. Some other questions that we're seeing right now in 221Gs are under what we refer to as flex postings. Employers that have a lot of locations throughout the U.S. will often post at multiple locations and then are identifying the location when you specifically are ready to come in. And so the consulates will often be confused about your posting used a wage from Nashville, which is where, say, the hospital's headquarters was, or Denver, where the hospital headquarters was. But this says you're going to go work in San Jose. We don't understand that. Again, part of the problem is that consular officers rotate positions and are generally not in positions long enough to actually get a real good, clear understanding of what the law requires. But flex postings are perfectly legal, have been around for probably about 20 years now, at least 15 years. But that, again, is a common question we're seeing. Another common 221G issue we're seeing is the whole idea of a license in a different state. So you got your ATT from Vermont, you took your NCLEX exam there, through there at least, you have a license in Vermont, and now you're going to go work at a hospital in Texas. And the consulate looks at it and says, well, how can you go work in Texas if you only have a Vermont license? Keeping in mind the requirement for approval of an I-140, you don't even have to have any state license. You simply need an NCLEX pass. So the consulate's just wrong on the law on that. But at least intuitively, that at least makes some sense, common sense. What's the connection between Vermont and Texas? So often you simply have to explain, well, they are going to endorse over, or whatever the case may be that's going to be allowed to allow you. So that's a common one that we see. Another common one we see is terms of your contracts. For employers that do use employment contracts, they will often be written in a way that are for a specific period of time, a 1 year, 2 year, 3 year. Sometimes they're written that way because they are tied to, say, a loan forgiveness program. So let's say that they've set up a program where they're going to pay to move you and your family over, and they're going to give you, say, $10,000 of moving expenses. And they're going to they're going to do that as part of a loan, and it's going to be a forgivable loan where if you work for them for 3 years, then they forgive the loan of that $10,000, whatever the number happens to be. So a lot of times that employment contract and loan forgiveness will be written within a term because that's how long you need to work to get the loan forgiven. So a lot of times the consulates will have trouble with that because the purpose or one of the criteria of a immigrant petition, an I-140, a green card, is that the offer is indefinite, okay? It doesn't mean you have to work there forever. It doesn't mean they have to employ you forever. It simply means that the offer is indefinite, though. It does not have a finite end date. Contrast that with, say, employment visas like an H or an L or a J visa. They have a specific time frame where they end. I'm petitioning you from this date to this date, the employment will end. Green cards don't have that. It's indefinite. So when you have an employment contract that changes that factor, that will often be another 221G issue. I think those are the most common ones we're seeing relative to our end.
All right. Very good, Mike. Thanks. We're already receiving a lot of questions are coming in through the chat function. And I would encourage you that if you do have a question, please do enter it in using the chat function of our webinar platform today. We will get to as many of these questions as we can. And again, if there are questions that you have posed that we haven't been able to respond to, please follow up with us. You can email those questions directly to me at rhoppe@healthstaff.org, and we'll do our best to respond to everyone in a very timely way. Mike, I know a big issue of area of concern and a question that we get a lot is how has COVID-19 impacted on the 221G issue and the processing of 221Gs overall?
Okay, good. Yeah, good question. So obviously, COVID-19 has had a significant impact on visa processing, 221G processing in particular. First of all, the consulates were ordered to stop all the terminology routine and normal processing of cases. That includes 221Gs. Now, that was lifted about a week and a half ago by a Department of State announcement that said they are now resuming routine and normal processing. So up until about a week and a half ago, all 221Gs at all consulates were halted. Now, there were some exceptions to that, okay? They were doing age out cases. So if you had a child that was aging out quickly, they were not treating that as normal and routine, but as a special case, and they were processing those cases. They also, individuals that were going into hospital facilities directly, we were applying for exceptions, indicating that this individual is working directly on COVID relief or providing relief for other RNs in the facility that would then be able to be working in the ICU unit for COVID relief. Those were being accepted as well. But generally speaking, we had just a ground to a halt, nothing being done, not being looked at, with very few exceptions, up until about a week and a half ago. Week and a half ago, announced, in theory, back to normal. Obviously, they still have short staff because of COVID-19, like a lot of companies. So we're not expecting them to all of a sudden take care of all of them immediately, but we certainly are expecting to see progress that we have not been seeing as much of over the past several months.
Hey, Mike, if I can just interject for a minute on this point, I think one of the very frequent questions that we get, and I think one of the points of frustrations within the nursing community generally, is this reality where some individuals have been scheduled for an embassy and they've just been granted their visa. Others have received 221Gs. Some 221Gs have been outstanding for a long period of time, and some have been resolved relatively quickly, sometimes even within days or a week. I know you've spoken to, some of the reasons why the 221Gs are issued in the first place. Just interested in hearing your thoughts on some of these processing inconsistencies, where an applicant might reasonably say, well, my friend had their embassy interview last week and it went smoothly, and I've been waiting on my 221G to be resolved for months.
Yeah, no, and that's the reality. And the reality is there's probably nothing different about your friend's case and your case. You guys might even be from the same agency, going to the same facility, et cetera, and you're going to get different outcomes. And that is unfortunate, but it is the reality, and it is not a new reality. This goes back, I've been doing healthcare cases since the early 2000s. So it goes back 20 years. It's not going to change, in part because of how they operate, with respect to the fact that they are often simply, if they've got 10 cases coming in on a specific day, they're going to simply take extra care on one case versus the other 9. So that is going to continue. There are, however, certain things that people have been able to do to try to push cases along. There are a variety of organizations that work to liaison directly with the consulate to move cases forward. Sometimes those are successful with large group issues, and then all of a sudden you'll see a whole big group of cases moved forward. But every once in a while you'll see a situation where 3 out of 4 cases facing that exact same issue get moved forward, and then 1 out of 4 will not. And that's obviously very frustrating to you, who is the 1 out of 4. But it is the reality of how the consulates simply operate right now. And again, it's nothing new at all. And in my opinion, it's not, and nobody likes to hear this, but it's not preventable. Because seriously, if you took your name and you looked at your petition packet versus your friend's petition packet, other than your names and where you guys went to school, you're not going to see any different. They're going to look exactly the same. So, sorry.
Okay. Yeah, Mike, no, thank you for that. I think that's very helpful. And that kind of is a good point for us to transition, I think, to the central question that everyone has on their mind. And that is, what is currently being done to resolve 221G cases? You had mentioned a variety of things and industry groups, et cetera. But right now, today, what would be, your commentary on what is currently being done to resolve these issues?
So for us, for the cases that we're handling, here's the steps we're taking. And I think most attorneys are doing similar things, okay? There's not a lot of magic involved in this process. Is number one, direct communication with the consulate. The consulate is very receptive to emails. They're slow, but they will respond. So we're doing a direct communication as what we refer to as group as well as individual. So on behalf of a particular facility or a particular hospital system, we will do group emails to the consult saying we have XYZ facility that has 4 outstanding 221G RNs. Some of them have been waiting since last December. We're getting close to a year. We need some action on those. Let us know what you need from us to help you resolve this case. Second thing, direct communication on an individual case-by-case basis. So we've got a group email that says you're going to go to XYZ facility. That's with maybe a list of how many RNs are going to that same facility impacted. Then there's a specific individualized email for you saying, hey, here's this 221G. It was issued on such and such date. What do you need from us? What can we help you with? What can we give you? Second thing that's being done is the Department of State in Washington, D.C. has something called LegalNet, which is a system that attorneys have access to that allows us to contact the Department of State about broad issues. And not specific cases, but about issues that we're seeing out of a particular post that we believe they're interpreting improperly, illegally, and ask for their involvement and their assistance. And that is being done routinely. And the attorneys that practice in this area, we share a lot of information, not about your specific case, but about trends that we see. And we will often kind of congregate together and coordinate an attack, so to speak, but a nice legal attack, not a bad attack, on the Department of State, saying so that they understand that over the course of a week they may get 50 emails from 50 different immigration attorneys saying here are the issues we're all seeing, hoping that they will react. And then the third thing that we have been doing is they created this provision for expedited handling, even while there was a ban and even while they were not resuming processing, where they would schedule interviews if you could demonstrate that you were providing direct care relative to the COVID crisis. We've gotten slightly more creative in addressing those. In theory, that provision is not supposed to apply to 221G cases because you've already had your interview. It is supposed to apply to individuals who've now been approved. They're waiting for an interview. They finished with the NVC, and we just need an interview scheduled quickly, even though interviews are not now generally being scheduled. However, we have been, over about the last 6 weeks, submitting requests for individuals stuck in 221G abyss in order to kind of just lodge the case loose a little bit. And we've had a couple successes with that. We've had a couple interview notices this week where they have been asked to come back in for another interview, which we're hoping that when they got that expedite request, that they looked at it and said, hey, the person already had an interview. We have a 221G issue. Can we get it resolved? Now let's bring them back in. That's what we're hoping happened. What we hope did not happen, but we've no way of knowing, is did they just honor our request for an expedite without looking at the history of the case to see that they've already been interviewed? And if that happens, then the person's going to come in, they're going to be in front of the window, and they're going to go, look, you already have an interview, you already have a 221G, we need to wait till that's resolved, and then that's going to be a waste. But that's certainly what we're trying to do. We've also been a little more creative. Initially, when we were asking for expedite requests, we were providing documentation to show how you were tied to going to be involved in COVID care. Again, we've gotten a little more removed from that and are talking about how you will, even if you're not in a facility that even maybe you're in a long-term care facility, you're not doing any COVID care, but you may be able to free up a position for someone who could move into a ICU unit or into an ER unit and provide some COVID. And the idea, there's so many nurse openings right now in the U.S. There's such a crisis going on. We're kind of hoping that they're going to lump kind of all nurses together, whether you are working directly with COVID care or not, and going to recognize the need for expedited processing. And again, at least the early results over the last 2 weeks have been fairly positive. So.
All right. Well, good, Mike. Thank you for that. We do have a number of questions that do continue to come in. And Mike, before we get to the questions on the topic that we've been focused on this morning, while we're with you, I'd like to ask you just a couple of other questions that are top of mind for everyone that's in any stage of the process at the moment. Mike, just share with us briefly what your outlook is currently for the visa priority dates.
I actually think they're going to stay current for the rest of this year, fiscal year, not just calendar year. They may retrogress a little bit at the end of the fiscal year as they use up all the dates, but that's typical. That's not that big of a deal. And then I think we're going to see stay current next year as well. Next fiscal year.
Yeah, very good. That would be just awesome to have the dates remain current for an extended period of time. I know we would welcome that, and I know another sort of question or thought that a lot of people have on their mind is, Mike, what do you see happening in the first few months of a President Biden administration, specifically as it relates to immigration and to nurses from around the world?
Yeah, I mean, I think the most important thing is what we're not going to see, in that we're not going to see continued restrictions. We're not going to see new things. There was just this last week put out a new policy that said even if you meet all the criteria under the law, that the examiner processing your case at the 45, which is the green card stage here in the U.S., if you're processing here in the U.S., the examiner can make their own decision and use their own discretion as to whether it be in the best benefit of the U.S. to have you here or not. So you can meet all the standards, check off all the boxes, and then under an executive order by the Trump administration in the last waning days of his administration, he's decided to allow individual examiners to say, you meet the standards, but I'm still not going to approve you. So I think the number one thing that we're going to see out of a Biden administration is we're not going to see stuff like that. Now, whether we're going to see a lot of rollback of a lot of policies, I certainly expect so. However, there have not been a lot of policies impacting the RN space. So there's not a lot of that. Most of the policies have affected asylum, family-based immigration, things like that. The Department of Labor reg that came out a couple weeks ago that I mentioned earlier, that's under litigation. We expect that litigation to continue on once the Biden administration comes in. Regulations cannot simply be withdrawn, but they can choose not to defend that regulation. And we expect that. So we expect that regulation will have a short life. So we don't expect more negative, which is good. However, because of the makeup of the Senate and Congress, we do not expect a lot of positive developments either. Again, for the RN space right now, you're not crying out for a need right now. Sure, we need retrogression relief, but not today. Today we're good. We're current. Is that going to happen? Are we going to have some of those types of relief, per country limit restrictions lifted, et cetera? Yeah, probably not. But I think overall, significantly more positive difference between night and day of what we've had for the last 4 years versus what we're going to have over the next 4.
All right, that's great news and good reason for optimism. Looking forward. Just the last question, Mike, before we do get into our Q&A time. I know that there was a lot of interest and some excitement around the Healthcare Workforce Resilience Act back since I think that came out in May of this year, April or May of this year. Any thoughts on whether that legislation might see the light of day in a new Congress?
I do not think so.
Okay. All right. Very, very good. Fair enough. Mike, thanks for that. We're gonna switch now, and we've got about 25 minutes remaining in our scheduled session today, and so let's see how many questions we can get through. So, Mike, the first question that has come in I think illustrates very well one of the points that you touched on earlier. But I'm going to share the question again because I think it is something that we can't speak to often enough. And so the question has come in. It says, let me see here. So what is the difference between 221G cases and returned to USCIS? So that's one question. And this individual goes on to say, I was interviewed January 2020 and was issued a 221G, not for lacking documents. After a couple of months, received a letter, stated my case was returned to USCIS, which is really frustrating. What's the next step for this kind of status? So, Mike, if you could just briefly answer that question again.
Sure. Once a case has been notified that it's been returned to the USCIS will normally receive that case in about 6 months. Okay, which seems crazy, but that's about their normal processing time. The USCIS normally has that case for about 3 months. If they're going to issue a notice to your petitioner, a notice of intent to revoke, they will normally issue it in about that 3-month mark. So normally within about 9 months, you'll have seen a notice of intent to revoke. And then your employer will have 30 days to respond to that. If you do not get a notice within those 9 months, then generally speaking, that means it's been returned to the consulate for them to go ahead and approve the case. Now, this is not a normal year. The normal time frames are not real right now. So whether things really happened in those 6 months and then in those 3 months, unlikely because of, people working remotely, consulates having shorter staff. They may not have even mailed it yet to the USCIS. The USCIS will not provide an update on those. Sometimes you can get a congressional update. So sometimes the congressman can reach out to the consulate and get an update from the consulate. But often it's generic update that your case is being processed. We only returned to resume normal processing a week and a half ago, kind of things. So it can be very frustrating. There's no premium processing option. So it's, unfortunate. And a lot of times people think, well, I can file a new case and that'll resolve it. Okay. Well, first of all, generally speaking, when you resolve a new case or when you file a new case, if your first case is under 221G, your second case is going to go under 221G as well. And so you're not necessarily going to have solved anything. But that is certainly something that we, from time to time, will try out of desperation. But I don't have a great answer for you other than that has generally been the time frame. I will also tell you one other thing to add to that. The majority of cases we see do not get sent back to employers for notice of intent to revoke. The majority of cases go back to the consulate with the USCIS telling the consulate, you're wrong, we're right, please process this visa. Now, I'm sure they say it nicer than that, but that's the effect of it.
Yeah. Yeah, Mike, I would agree with that. I think for the 221G cases that we've encountered here at WorldWide HealthStaff, I'm not aware that we've received a notice of intention to revoke in relation to any of those. And I appreciated your comment of saying that if your 221G has been outstanding for 9 months or more, it is likely that it has been returned to the consulate with direction to approve.
Yeah.
I'll just share this question again, Mike, because I think it's very, very indicative of the experience that applicants are having. I think it's very indicative of the frustration that applicants are having. And again, we've touched on this, but I think it's worth circling back and revisiting again. And so this has come in through the chat function. It says, 2 nurses with the same company / agency had an interview at the Manila embassy with different consuls. Both cases, or one case was put on 221G. One nurse got her visa issued while the other nurse was sent back to USCIS for further review. Again, two nurses, same employer, same agency. Question is, with this scenario, why did one nurse get her visa and the other one with the same agency and the same company have their case sent back to USCIS? Again, how long do we need to wait before the cases get reviewed? Should we refile, or can we file a lawsuit? What is the best action?
Yeah, and this is just my opinion as to why that happens, is a lot of times consulates have a particular perspective on how something should work. And they're wanting some affirmation from the USCIS as to their interpretation. And so they have chosen your case to send back to say, we do not believe a visa should be issued if, let's say, the employment contract has a 2-year time limit on it. And it's unfortunate for you. It wasn't a personal issue. It's simply they're looking at the bigger picture, and they're saying, we want a legal opinion from the USCIS, California Service Center, whatever, as to this particular issue. Your case just happened to be the one chosen. Again, refiling generally does not help. Again, often we try simply out of frustration at some point, but we generally don't accomplish much by doing that. Continued follow-up and continued review is the best approach. Rarely would you ever file a lawsuit on an individual case. It would have to be something extremely egregious. There's a doctrine of what they call consular non-reviewability. There would be a whole series of things that you would do before you would go the lawsuit route.
Yeah, I know, Mike, that some of the industry groups like the American Association of International Healthcare Recruiters, of which WorldWide HealthStaff is a member, has taken a very strong advocacy position, a very strong lobbying position, and even has had legal intervention in this matter in an effort to accomplish, the outcomes that you've been referring to here in our time today. Just a quick comment. I see that some of you are raising your virtual hand using the speak function on our webinar platform. I would ask that you instead please just quickly type out your question in the chat area of our platform. That's the easiest way that we can get to you. Mike, just changing tracks here very briefly for a moment. We've received several questions around prevailing wage determination, and specifically the length of time that it's taking. How long should it take? How long is it taking for employers to get prevailing wage applications? I know that with the shortage of nurses, many employers, when they make the decision to recruit internationally, then immediately want to get into the interview and recruitment process, and then they're not able to file their petitions immediately. So just if you could take a moment and just talk to that prevailing wage process and the prevailing wage timeline.
Yeah, the timeline varies whether you're going to be at a union facility or a non-union facility. Union facilities take about 60 days longer because of the different notices that have to be provided to the union. But generally speaking, prevailing wages right now are running at about the 120 to 130 day mark. So they were at about 90 days throughout the summer, but probably since about September have escalated to 120. I have one right here that came in yesterday that was filed on July 7th. So okay, that puts us at about 130 days, somewhere in that neighborhood, 132 days. So that's about what we're running into now. We do not believe that the new OES wage system is impacting the slowdown in wages being issued. We have a few theories. New budgets went into effect October 1st. We believe that since we've gotten significantly slower since October 1st, we think it's a little bit budget related. We do not think it is COVID work from home related, because this particular department had been 75% work remotely prior to COVID. So, we're also hopeful that that's a short-term thing, but right now it's taken forever.
Yeah.
And it's not affected by the timing is not affected by the new regulation.
Right. And I think that experience is pretty consistent right across the board with everyone that's involved in our industry. I know from our perspective here, where as much as it's possible, we're trying to get prevailing wage applications started as early as possible in our dialogue with new clients, so that even while the contracting process plays out, that we've already got that clock running. And I know, Mike, I know that you and we together work with clients that are recruiting on an ongoing basis. And there it's much easier to keep a current prevailing wage because we're just applying for renewals on a rolling basis.
Correct.
All right. Let us see what other changes or questions we have here, rather. Question, Mike, has come in. If the dates in the SEAC tracker system change, does that mean that the consul is reviewing my application? Is it better for my employer or attorney to dispute with my case if no updates from SEAC?
Well, it means there's some action, whether that means they're reviewing or whether they're just updating. It doesn't necessarily mean they're reviewing. It just means they updated the dates. So it's a face value thing. That's all it means. Whether it's worth continuing for them to pursue, I would say most of the time, yeah, absolutely. Because until you get it resolved, until you get to the end of the finish line, you're not there. Mm-hmm. So I do think whoever the attorney is and whatever the company is that you're asking about, I think they should continue to pursue it until you've got it in your hand.
Yeah.
So, yeah.
Now, obviously, if you're in the position of having waited for a visa for an extended period of time, we had an applicant, just quickly, anecdotally, we had an applicant visit us at our office here yesterday. They just arrived in the U.S. a few days ago. He had started from the time his first petition was filed with another agency. It had been almost 10 years to the day since he first started on that path until he arrived, having gone through several agencies and eventually having connected with us. So I get the anxiety and the frustration, but Mike, I think there's some misunderstanding. When we say follow up, we should follow up with SEAC. We should make various follow-ups. Is it helpful for these follow-ups to be daily?
Absolutely not.
Okay. Can you just explain that a little further, please?
Give the government an opportunity to then process your case. So you follow up. There's no reason whatsoever to follow up again that next day or the next day or the next day after that. In my opinion, even 14 days is too short. Now, if you've got something urgent where they have responded back to you and you're exchanging, okay, that's different. But in a general scenario where you are, I'm trying to follow up on this, I haven't been scheduled for my interview, or I've had a 221G, and I don't have an answer yet. You need to give them a reasonable period of time. If, in my opinion, you can follow up too often and get buried. And the fact that maybe that's not how they're supposed to operate, I will tell you that is how they operate. And frankly, that's the way everybody else operates too.
Yeah.
The other thing, I think you have to be reasonable as to, is my case really out of processing time or is it not? Keep in mind, the consulate stopped processing cases, except for expedite and age out cases since, was it March, April? They only resumed a week and a half ago. So we've got 6-7 months where they weren't working on your case. And they weren't working on anyone else's.
Yeah.
And they're not going to pick all of them up the next day. And we have to understand that even though personally that's horrible for us individually, there's another 1,000 individuals who are in the exact same situation and they can't process all 1,000 cases the first day. I'm not generally a very sympathetic person to the consulars, officials, or to anyone else for that matter. It's probably a character defect of mine. But I think in this situation, I think we have to be realistic about how often we follow up and how often we are pushing that, our agenda.
All right, good, very good. Mike, interesting question. I think it's very relevant to the conversation that we've had so far today. And the question is really a very simple one. And the question is it safe to schedule an interview at the Manila Embassy right now, given the 221 issues ongoing?
In my opinion, it still is, because first of all, we are still seeing, and this is positive and negative, inconsistent results. So we're seeing people given visas daily. You might be that person. Secondly, there's never been a time in history where we haven't dealt with 221G issues. Now, maybe it's a little worse right now, but I can refer back to a lot of periods of time where it frankly was worse than it is now. So in my opinion, pursue. You might be one of the people that gets approved. If not, you're at least in the queue. So I would definitely not defer because of a fear of 221G. Defer for a lot of other reasons, family reasons, health reasons, job offer reasons, all the other stuff, but don't defer because of 221G.
Yeah. Mike, we have just a few minutes remaining, so I'm going to try and get us to a couple more questions. Next one, question that has come in says, I was required by the embassy in Manila to have another valid medical exam because my old medical exam had expired in July. I did not go to that interview based on advice I received. My case is due. I'm due for an interview this December. Is there anything I can do to go ahead with this interview date? I just want to follow up to make sure my new medical is not going to be wasted.
Well, the Manila consulate provided a 1-month extension for validity of medical exams, but it was only for a very limited period of time. I believe there was a 90-day window back in the spring where they extended. Beyond that, they have not extended, and they do not have the authority to extend medical exams beyond that. So if your medical exam is expired, I would definitely get a new medical exam. Okay,
very good. Let's see, other new questions that have come in. Oh, this is an interesting one. Will the amount that is indicated in my job offer letter regarding breach of contract be the reason to be put under 221G? I've heard of some cases where people were placed under 221G due to very large amounts written into their contract under the breach provisions.
And so, yes,
any sense of that, Mike? And I know we hear from applicants fairly regularly where they've gotten themselves into arrangements where the contract says, $40,000, $50,000 and more dollars breach.
Yeah. Well, first of all, yes, that can be a ground for a 221G. The consulate's taken a hard line on liquidated damages clauses. My legal opinion to my clients, and again, I'm just the attorney. That's all I am. I'm nothing else. I don't make decisions, but my legal opinion to my clients is that you should not have any liquidated damages clauses in your contracts, regardless of the amount, whether it seems a reasonable amount, $5,000, $50, or an unreasonable amount, $30,000, $40,000, whatever. I do not believe you should have one in your contract. So yes, there's certainly a risk of going to a 221G for a unreasonable liquidated damages clause. And the fact that attorneys can defend liquidated damages clause and say the law allows it, that is true. That's 100% correct. The law does allow it. However, there have been a whole lot of cases in the U.S. about liquidated damages clauses over the last several years that have put a different light on them. That, in my opinion, it's crossed the line and is no longer wise to have liquidated damages clauses in contract.
Yeah. I agree, Mike. I think those types of provisions that not only are 30 or 40,000, but in some cases are actually open-ended for even larger amounts is definitely an issue and is definitely a concern. We do have a few other questions that I think are fairly directly related to those that we've already touched on. Mike, just as we wrap up this morning or this afternoon, depending on where our attendees are at, any closing thoughts or words of encouragement that you might share with those that have joined us?
Well, I would say probably I guess probably the biggest picture would be that things are right now, regardless of your individual circumstances, more positive than they've been in a little while. From a big picture perspective, we have no retrogression for most categories. Outside of India and China, virtually none. We don't expect any for the next 18 months to 2 years. That's significantly different than what we've experienced over the past several years. That's huge. Number two, we still have premium processing for I-140 petitions. Even though it's gotten a lot more expensive, we still have that as an option. Number three, even though there's Department of Labor regs that are potentially changing the wages, we have an alternative to that in virtually every market. So I do not believe that will be a hurdle. So when we're looking at this big picture perspective of I'm an RN and I want to be able to come to the U.S. and work and ply my trade as an RN in the U.S., I think the opportunities today are great to do that. Obviously, the job market is tremendous right now. Tons of openings. And I do not think they're going away. This is not simply a COVID bump. Sure, there's a COVID bump. But we already had such high demand that it only took it from here to here. It's maybe goes back down to here. It's still way above the norm. And I don't see that going away. So I would be very bullish, very positive on RN to the U.S. And again, with Trump out of office, there's one big, huge orange hurdle out of the way.
All right. Well, Mike, thanks so much for taking time to be with us today. I know that speaking on behalf of all of us here at WorldWide HealthStaff, we very much appreciate the relationship that we have with you and your firm. And we look forward to continuing to work together and making it possible for many, many nurses to arrive here in the U.S. as permanent residents. Thank you to all of you that have attended. We've had great live attendance today, and even more individuals that have registered that will receive a recording of this session sometime probably tomorrow. So thank you to each and every one of you. If you are an existing WorldWide HealthStaff Solutions applicant and you have a question that maybe wasn't specifically answered in our time together today, please reach out directly to your case manager. They are here to help you and to walk alongside with you every step of the way on your journey to the U.S. If you've joined us today and you are not an applicant an applicant of WorldWide HealthStaff, or if your case isn't being managed by Mike and his group, feel free to reach out to us just generally through info@healthstaff.org. If there's any other information that we can provide to you, we'd certainly be happy to do so. Again, I do appreciate everyone's interest and participation in our webinar session today. We look forward to similar opportunities to share meaningful, timely information with the international nursing community at large. At WorldWide HealthStaff here today, we continue to recruit very actively, even right through to the end of the year. We've got a number of recruiting initiatives that are about to be underway, and we'll have many new opportunities heading into the new year. So please be sure to pass that information along to your nursing friends and colleagues. Mike, thank you again.
Thank you, Ron. Appreciate it.
Thank you to everyone that's attended today. We're here to respond to any questions you have, and I hope that all of you have enjoyable rest of the day and enjoy your weekend ahead. Thanks and bye for now.
Appreciate it.